Well, welcome to today's session. It's on UK GDPR and money laundering, and this one's given in partnership with GI Outsourcing. So just a few things to look out for and why. We'll start then with looking at GDPR. This was introduced in 2018 purely because previous legislation was introduced about 20 years ago. So as you can imagine, the technological landscape has changed entirely since then. So the previous legislation was not up to the task. It's been very high profile in the news that there's been a lot of identity theft, there's been a lot of phishing, and there's been a lot of unsolicited marketing. So this legislation was introduced to give individuals back control of their own data, but also to make organizations and enterprises aware of the fact that they are responsible for that data when they're processing it on behalf of those individuals. So the average cost of a data breach globally last year was just under $4 million. So you can see there's a lot of costs involved. And just to put that in perspective, that works out at around $150 per lost record. And that gives you some kind of perspective if you look internally, if you think about how many records you have, and so the related costs, potential costs involved to you. The causes of those breaches, by far and away, the biggest is malicious attacks. As you can see, those figures there, that's gone up 10% in the last 7 years. And the reason for that is, as I mentioned, because there's now so much more data that's held remotely in the cloud. If you can unlock the keys, you have the key to unlock that door, you then have access to so much more potentially valuable information if you're a malicious third party. There are also systems glitches around 25% and roughly the same for human error. It's important to note that figure for human error because that in particular can be addressed through training, through courses such as these. So just making people aware of the fact of possible repercussions, those figures there regarding malicious attacks, and just small things that people can do to help combat that, ensuring that your antivirus software and your firewalls are up to date, that people close their workstations when they leave their desk. They don't leave any sensitive hard copies out on the desk when they leave the desk, that kind of thing. Very simple steps, but very effective. That's legislation. So what does it actually cover? It covers personal data and a subcategory of that, which is sensitive data. Personal data is classified as, under GDPR, as anything that can reasonably be expected to identify an individual, either on its own or in conjunction with a second piece of information or more, which you can reasonably expect to get hold of. So it can be things like your name, email address, ID numbers, your location data, and that can be your physical location or your online identifiers, your IP identifiers, that kind of thing. It can also cover photographs, and the reason I'm bringing that up is it's very important to note that when you gather data, two different organizations can gather the same data, and depending the purposes for that data, why they gathered it, one organization will be covered under GDPR legislation and the second won't. And so by way of example, if we look at a photograph, if a photograph has been taken of a group of people who are attending right now a topical football match, if it's just to show that that's a well-attended match, then that photograph does not pertain to any one individual in that photograph in any particular way, form, or function. So it is not covered by GDPR. If, however, one of the individuals in that photograph has told their employer that they can't work because they're ill, for example, and then that photograph is used either as part of a disciplinary or it's now held on their personnel record, that now pertains to that individual, so it is now covered under GDPR. So it's a subtle difference, but it highlights the principle very well. Sensitive data is, as you would expect, it's much more personal data or sensitive to the individual than regular personal data. So it will be related to things as maybe your religious or your philosophical beliefs, your trade union membership, your sexual preference, things like this. So it's much more sensitive data, and do be aware of the fact if you're going to gather that kind of data, you have to get very, very specific permission and consent from the individuals involved. And you have to be a lot more granular with them as to what data you're gathering and why, the purposes, who you're going to share it with, and more to the point, how you're going to destroy it afterwards when you've achieved your stated aim. GDPR compliant processes, the first of these is to carry out a full data inventory. Now, by that, I mean you map the data flow from the point you gather your data to the point it's destroyed. So you're aware of all the points in that process, who has access to that data, the third parties, what security you have at different points all the way through the process, and how long you're going to keep it, where you're going to keep it, and how you destroy it. That's also important. So if you quite legitimately receive an inquiry from an individual as to what data you hold on them, it means it's much easier and quicker to access that data when you have that data map in place. It also demonstrates, if you have investigation by the Data Protection Authority, which is the Information Commissioner's Office in the UK, that it demonstrates you have tight controls and full knowledge of what's happening to the data under your control at all times. Lawful grounds, you need to have lawful grounds to gather this kind of data. There are 6 lawful grounds, which are all beautifully explained on the Information Commissioner's Office website. They also have a very, very useful and user-friendly and interactive questionnaire on there if you're unsure about the most appropriate legal grounds for processing the data. Sometimes the results are not clear-cut, in which case, by all means, contact the ICO and they will give you further advice. But it's a very, very useful tool. Special category data I've covered, but do also be aware of the fact you will need to complete what's known as a data protection impact assessment, which is another phrase for basically a risk assessment. So you gather information on the likelihood of data breach and the anticipated severity of the impact on those individuals involved if there is a data breach involving them. Ensuring the security of the data you gather, this is both the IT part of it, so making sure, as I mentioned, that your IT is up to date, your firewalls, your antivirus software, that kind of thing, making sure that your staff are well trained on being aware of, maybe, for example, if they're using mobile devices, what are your policies, ensuring that not only can you maybe lock those devices, can you wipe them remotely if you need to, that kind of thing. The cookie policy, this needs to be visible on the bottom of each page of your website. And when you first access your website, you need to gain consent before you launch any cookies other than the cookies absolutely necessary for the functioning of the website. So any kind of tracking, any kind of logistics, any of that kind of tracking, you have to gain consent from individuals before you launch those cookies, and you also have to retain that consent on file to be able to demonstrate you've gathered it in the event of an investigation. And also, you cannot pre-populate a consent box to say you have to actively opt out of giving consent. It has to be the other way around. People have to actively opt in to give consent. The last point there of the compliant processes is publishing a privacy notice. That needs to, again, be visible at the bottom of each page of your website, and it'll be a summary of everything I've just been through. It'll clarify what data has been collected, what are the legal grounds for that collection and processing, who else will that data be shared with, and also who is the point of contact in your company or organization if an individual wants to either submit a complaint or they want to see what data you hold on them to ensure is current and accurate. So do be aware of that. Lastly, this is not by any means a definitive internal audit checklist, but it's a great starting point. So this will vary according to what kind of data you gather, the sector, even the country you're in. But I say it's a great starting point. So look at how does your organization gain consent? How can customers withdraw that consent as easily as they give it? How secure is that data? As I've mentioned, that involves both the IT, maintaining your IT up to date, and also the training. breach prevention and management, this is not just preventing the breach, but the management is you need to make sure you have the procedures in place, that somebody's been allocated to both address the breach, and you have 72 hours for them to report any breach to the Information Commission's office, and to follow up and contact the individuals involved if necessary in the event of a breach. So don't leave it until the breach has happened. Make sure you have those procedures in place in advance. I've covered the lawful basis of processing data. Do you actually have marketing campaigns? Do you have the relevant consent for that marketing? What kind of personal data do you hold? Is it necessary to hold as much as you do to achieve your stated aims? And lastly, do you outsource the processing of that data? If so, what are their security procedures? You need to make sure that any third parties you use and outsource to are also GDPR compliant. That's very important because it is your responsibility as the data controller. So that was a very quick run through GDPR. We're now going to look at financial crime and in particular money laundering. As you can see, there are a number of other categories of financial crime, but today we're just going to focus on the first one, which is money laundering. Most people have heard of money laundering, but it's important that your staff are aware of the stages involved in a money laundering process. So when a criminal has gained funds from illegal activity, it could be anything, it could be drug smuggling, people smuggling. It could also even be legitimate funds, but the legitimate tax hasn't been paid on those funds. Then the first thing criminals will do is they will look to place those funds, those illegal funds, in legitimate financial vehicles. So it could be anything in a savings account, it could be an insurance policy, it could be anything. Then they will take it out of that legitimate source, and then they will put it to another source, and they will keep on placing it in a process known as layering until the source of those funds becomes so opaque that you can't see the original illegitimate or illegal source of those funds, at which point those funds are deemed to be integrated because they look now as if they're legitimate. So it's important that your staff are aware of that process. Some warning signs then that money laundering may be involved is individuals taking out, cancelling expensive policies for no reason. If these policies are taken out, or if there are refunds of claims and they're awarded to unconnected or unrelated third parties, that should raise a red flag. If individuals have activities which are not in line with their lifestyles or their living standards, so you will tend to be aware of somebody's salary, for example, if they're depositing it month after month, but then if all of a sudden they're depositing funds which are 10 times the annual salary, that is a warning sign that there might be money laundering involved. And lastly, again, this is not a definitive list, but in this list, large payments in cash, travelers' checks, money orders, where obviously it's very, very difficult to identify the original source of those funds, could also be a warning sign. That's the actual process of money laundering. So I'm now going to look at the directives in place, that put in place to combat the money laundering. We're going to just look briefly at the EU money laundering directives because they're incorporated into the UK legislation. So you can see the 5th money laundering directive. This was passed in January of last year. The whole point of this MLD was to improve transparency across the EU region, and it's basically to ensure that people are regarding money laundering in the same terms, so you've got a unified approach to combat it. Some of the key points of the 5th money laundering directive which were introduced is it's more all-encompassing. So newly obligated entities, things like cyber currency is now included in the money laundering directives. The art market, art trading was a big way of laundering money. That's now included in the legislation. There is more stringent customer due diligence, which is your basic due diligence as people just come to deposit funds with you. But there's more stringent now red flags in place through which will trigger enhanced due diligence, where you put additional checks in place if these red flags are raised. Some of those red flags are the fact that certain industries like the extractive sector is more prone to money laundering. The financial sector, also people involved are politically exposed persons. By that I mean it's individuals either if they are senior in the legislature, in government, in the armed forces, they're more likely to have access to public funds. They're more likely to be able to abuse public office, and because of their high profile, they're more likely to be subject to blackmail as well. So again, these are all red flags that when you're training your staff, they need to be aware of. These are just some additional requirements specific to banks and financial advice firms as the result of the fifth money laundering directive. So I've mentioned training already. Staff need to be aware of these red flags, and they need to know what are the next steps, not only just how to recognize them, who do they inform and how, and also staff vetting. It's very much risk-based. So if it's a more junior role, then you'll just be expected to do very, very generic background checks and just follow up on references. If it's a more senior role, you'll be expected to do maybe DBS background checking and some further investigating. There needs to be more structured reporting and internal auditing, and also at the end of the year you need to produce an annual report which will document what you've actually done in terms of training and auditing. Those levels, the in-depth levels, will relate to the how in-depth and complicated the transactions are of an organization. So it is quite a simple transactional structure. It'll be very basic. If you have more of a global organization with very involved transactions, then as it's risk-based, it's more likely to involve money laundering. So you would be expected to have more stringent auditing procedures in place. One of the last things here is to look at is you will also be expected to appoint a money laundering compliance principal who is responsible for the anti-money laundering policies and procedures in an organization. And more on a day-to-day basis, you have a money laundering reporting officer, and that officer will be the person that the staff will report their initial suspicions to, and the reporting officer will decide whether or not that needs to be escalated, or there's no case to answer, that's one of a better phrase. Also, do be aware of the fact that the compliance principal and the reporting officer can be one and the same person. It does not have to be two different individuals. The sixth money laundering directive was introduced in December last year. It closes some loopholes from the fourth and fifth money laundering directives, but do be aware of the fact it extends criminal liability to enablers, by which I mean it's not just the people who benefit from the money laundering, but anybody involved in encouraging others to get involved in money laundering or who enable money laundering to take place. And it introduces harsher punishments, so the custodial sentence goes up from 1 year to 4 years. Do be aware of the fact that the UK, although they've incorporated all 5 previous money laundering directives into legislation, they have opted out of incorporating the 6th money laundering directive. This is on the basis that the anti-money laundering legislation in the UK is already either matches or exceeds the requirements. So the sentence, according to the EU money laundering directive, is 4 years custodial sentence. In the UK is up to 14 years. So it does exceed in certain areas, but do also be aware of the fact that if you are dealing with other financial bodies within the EU, you will still need to require, so you'll still be required to adhere to the 6th money laundering directive requirements. So thanks very much for your attention. I know that was quite a quick run through of a lot of information. But if you would like more information, or if you have any queries you want to follow up in any way, then please do contact James Marshall, as you can see on the screen there, and you have his email address, and he will be only too delighted to answer your responses or follow up with us as necessary. So thanks so much for your attention, and I hope you enjoyed the course.